A very good morning to all my dear students and listeners. Today we are going to continue with our previous topic which we have dealt it yesterday. The topic is caveat. As you all are aware that we have discussed in our previous class or previous lecture about the meaning of caveat, to which I have apprised you that caveat has not been defined in the code, and the said word caveat has been derived from Latin word which means beware, and it has also resemblance with another word, that is caveat emptor, which is given under the section 16 of Indian Partnership Act, which lays down the rule regarding caveat emptor, which means let the buyer be aware. So from this, an analogy can be drawn to that effect that there is an interplay between the Partnership Act 1932 and the Code of Civil Procedure. As I have already apprised you that the word caveat has not been defined, but it can be defined in one of the leading law dictionary that a caveat is an entry made in the books of the offices of a registry or a court to prevent a certain step being taken without previous notice to the person entering the caveat. In other words, a caveat is a caution or a warning given by a party to the court not to take any action or grant any relief to the applicant without notice being given to the party lodging the caveat. And thereafter, I have given you an example in which the caveat is most commonly being given, and these are the proceedings pertaining to testamentary proceedings, because it is a precautionary measure taken against the grant of probate or letter of administration, as the case may be, by the person lodging the caveat. As far as the provision regarding the lodging of caveat is concerned, the same is given under section 148A of the Code of Civil Procedure. Thereafter, I had also apprised you about the object of the caveat, wherein I had apprised that there are twofold objectives. Firstly, that is to safeguard the interest of a person against an order that may be passed on an application filed by a party in a suit or proceeding instituted or about to be instituted. Such a person lodging a caveat may not be necessary party to such an application, but he may be affected by an order that may be passed on such application. Secondly, to avoid multiplicity of proceedings. So, by virtue of, on the recommendation of the Law Commission, the said provision, that is section 148A, was inserted in the Code of Civil Procedure 1908. Thereafter, I had also discussed with you the nature and scope of caveat, wherein I had apprised you that a caveat can be lodged in a suit or a proceedings, and also apprised you with a leading case on this, that is the case of Ramchandra versus State of Uttar Pradesh, wherein the expression civil proceedings used in section 141 of the code includes all proceedings which are not only original proceedings. Thus, the provisions relating to caveat would be applicable to suits, appeals, as well as other proceedings under the code or under any other enactment. Thereafter, I had apprised you who may file this caveat. Subsection 1 of section 148 prescribes the qualification for the person who intends to lodge a caveat. He must be a person claiming a right to appear before the court on the hearing of the application, which the applicant might move for the grant of interim relief. Thus, a person who is a stranger to the proceeding cannot lodge a caveat. But a person who is affected by an interim order likely to be passed on an application against him in a suit or in a suit which is going to be instituted, then he may file a caveat in a court of law. Thereafter, I had also apprised you where caveat does not lie. The provisions of section 148 can be attracted only in the cases where the caveator is entitled to be heard before an order is made on an application already filed or proposed to be filed. The section cannot be construed to mean and provide that even in cases where the code does not contemplate a notice, it can be claimed by lodging a caveat. Such a construction would be inconsistent with the object underlying section 148A of CPC. Thereafter, I had apprised you that there is no format prescribed for the lodging of caveat in a court, and there is one exception to this rule, and that exception is given under the Indian Succession Act, wherein a format has been given. Under the CPC, a petition or the caveat can be filed in the form of a petition. So this is all we had discussed in my previous class with regard to caveat. Now I am going to start with the rights and the duties of the parties to the caveat. The rights and duties of the parties of the caveat are given under subsection 2, 3 and 4. Before going to dwell upon the same, I would like to mention the who are the parties to the caveat. Therefore, as far as this is concerned, there are three parties, that is the caveator, applicant and the court. So these are the three parties mentioned under this caveat application. Subsection 2, 3 and 4 prescribes rights and duties of the caveator who lodges a caveat, of the applicant who intends to obtain an interim order, and of the court. Under subsection 2 of section 148A, once party is admitted to the status of a caveator, he is clothed with the certain rights and duties. It is his duty to serve a notice of the caveat lodged by him by registered post on the person or persons by whom an application against the caveator for an interim order has been or is expected to be made. So from this we may infer that the person who wants or who lodges a caveat in the court of law, they have to give a notice to the other party from whom he has the apprehension that a case may be filed against him, and he can serve it through by way of registered post, so that the other person may give him a copy thereof, but at his cost. This concept or this particular rule is laid down in the next sub rule. The provisions with regard to Rule 2 is directory in nature and not mandatory in nature, where the name of the person is not known against whom the against whom the where the name of the person is not known to the caveator, then also a caveat be lodged without naming the party respondent. Now, what are the duties of the applicant? Once he received a copy of caveat from the caveator, then it is his duty of the applicant to furnish to the caveator forthwith at the caveator's expense a copy of the application made by him along with the copies of paper and documents on which he relies. So he has to provide a copy of his case which he is going to institute against the caveator. This is the obligation under this rule, is to provide copy by the applicant to the caveator, but at the expense of the caveator himself. Now, next, what are the duties of the court? Once a caveat has been lodged, it is the duty of the court to issue notice of the application on the caveator. This duty has been cast on the court for the purpose of enabling the caveator to appear and oppose the granting of interim relief in favor of the applicant. So, from this, we may infer that the court's duty is to give an opportunity of being heard. That is the one of the principle of natural justice, or the alteram partem. So this duty of the court is in addition to the duty of the applicant, and non-compliance with it defeats the very purpose or the very object mentioned under subsection 4 of section 148A CPC, and the breach thereof vitiates the order. So from this we may infer that if the court fails to fulfill its duty, thereby not giving him the opportunity of being heard, then in those cases the appellate court may set aside the order passed by the trial court against the caveator on this particular ground. Now, what if there is a failure to hear the caveator? It is clear that if the condition precedent for passing an interim order to serve a notice of the application on the caveator who is going to be affected by an interim order, but an interim order passed without hearing the caveator is not without jurisdiction and operates unless set aside. So from this we may infer that it is the condition precedent for passing an interim order to serve a notice to the application of the application on the caveator who is going. So from this we may infer that it is the duty of the court to give notice to the other side, that is to the caveator, and if court fails to gives an opportunity of being heard to the other side or to the caveator in this particular case, then it may vitiate, but the court may pass an interim order with regard to it. And before making the interim order absolute, it is incumbent upon the court to give an opportunity of being heard to the caveator. Otherwise, the order would be set aside by the higher courts. Now, next question. What is the time limit of a caveat? That means for how much duration the caveat would remain in force. A caveat lodged under subsection 1 will remain in force for a period of 90 days from the date of its filing by the caveator. So from this we may infer that the time duration for which this caveat would remain in force is that of 90 days only. And after the completion of 90 days, if he still is having any apprehension that a suit may be instituted against him, that is the caveator, then in that particular circumstance, he may again file a caveat in the same court or in any other court in which he may thinks fit that a suit may be instituted by the same party against him. And with regard to the applicability of res judicata is concerned, the second application for caveat would not be barred by the principle of res judicata. The reason for the same is that the res judicata applies only to the merits of the case. As such, the matter has not been decided and no opportunity of being has also been provided. So so there is no question of res judicata being raised. Hence, the res judicata would not be applicable in this circumstance. This is all for today's lecture. And in my next lecture, I would like to dwell upon another concept of law given under the Code of Civil Procedure, that is restitution and inherent powers of court. The provisions or the sections relevant for the restitution is given under section 144 CPC, and for the inherent powers of court, the relevant provisions are given under from section 148, 149, 150, 151, 152, and 153 3A and B. So this is all about today's lecture. Hope you have learnt a lot from it. In case of any query, you may write to me on my email ID, that is rahularora.gn@jagannath.org. Hope you have a good day ahead. Thank you very much. Stay home, stay safe, and be positive. Thanks once again.